Okay, I'm going to revisit a topic that I talked about back in 2019. And because I think this can be used, and it's like the more you learn about these different doctrines, laws, and, you know, a clearer understanding about what's going on with the courts and how they're moving, you can actually get a little creative about how you can use these things instead of just one way of seeing it. And during that time when I first learned about the fruit of the poisonous trees, I only thought about one example. Well, not one example, but similar scenarios that were almost pretty much the same. Now, fruit of the poisonous trees is a doctrine that extends the exclusionary rule to make evidence inadmissible in court if it was derived from evidence that was illegally obtained. It was the evidence that was illegally obtained. As the metaphor suggests, if the evidential tree is tainted, so is its fruit. The doctrine was established in 1920 by the decision in Silverthorne Lumber Company versus United States, and the phrase "fruit of the poisonous tree" was coined by Justice Frankfurter. If I'm saying his name now, Justice Frankfurter, in his 1939 opinion in Nordon versus United States. The rule typically bars even testimonial evidence resulting from excludable evidence, such as a confession. Okay, so like the exclusionary rule itself, the doctrine is subject to the three important exceptions. The evidence will not be excluded. Say that the evidence will not be excluded if it's three things. If it was discovered from a source independent of the illegal activity. Say it will not be excluded if its discovery was inevitable. Okay, and it would not be, say the evidence will not be excluded if, number three, for the evidence, the evidence found as a result of excludable voluntary testimony from the defendant. Okay, so those are the three ways it won't be excluded. Okay, but if someone is, I'm gonna give an example. This is the example that it's easy to kind of explain it with. Say, if the police runs up in your house, no warrant, you never gave them consent to run up in your house. And keep in mind, the Constitution says that you have the right to be secure in your persons, papers, and property, stuff like that. You have that right to be secure in that. They don't have no probable cause. They don't have no warrant to go up in there. You know, you don't have a warrant. They don't have your consent to go in there. So if they buzz up in there and they find weed, they can't arrest you for possession of weed, for possession of marijuana, and using that evidence, that weed, as evidence to prove their case, because they didn't have a warrant to come in there in the first place. That's fruit of the poisonous tree. That's one example. That's one of many examples, actually. And I just thought about, as a matter of fact, when it says exclusionary rule, I'm going to click on that. I'm reading from Cornell Law, in case y'all wondering where I'm at. Exclusionary rule, it says an exclusionary rule prevents the government from using most evidence gathered in violation of the United States Constitution. This is why I made this video, because what evidence, as a matter of fact, what evidence they talking about? When they say evidence is also it's a hyperlink. Evidence is a term for information. Evidence is an item or information pro-offered to make the existence of a fact, or a fact more or less probable. Okay, I'm gonna read that again. Evidence is an item or information pro-offered to make the existence of a fact more or less probable. It says evidence can take the form of a testimony, documents, photograph, videos, voice recordings, DNA testing, or other tangible objects. Let's see. Courts cannot admit all evidence as evidence. Must be admissible under the jurisdiction's rule of evidence in order to be presented in court. Say in federal court, evidence is governed by the federal rule of evidence. A court may exclude evidence because it is not relevant, is hearsay, or otherwise inadmissible. So that's the definition of evidence. So you're just kind of revisiting that part. Now back to exclusionary rule, when it says the government that rule is it prevents the government from using most evidence gathered in a violation of the United States Constitution. The decision in Mapp versus Ohio established the exclusionary rule applies to it established that the exclusionary rule applies to the evidence gained from an unreasonable search or seizure in violation of the Fourth Amendment. The decision in Miranda versus Arizona established that the exclusionary rule applied to improperly elicit incriminatory statements gathered in violation of the Fifth Amendment, and to evidence gained in situations where the government violated the defendant's Sixth Amendment right to counsel. However, the rule does not apply in civil cases, including deportation hearings. Well, that's all it says, including deportation hearings. Let's see. So, exclusionary rule. So, if anything that violates the Constitution, and they get some type of evidence that they obtain that violates the United States Constitution, then that will be considered fruit of the poisonous tree as well. So, it say fruit of the poisonous tree is a doctrine that extends the exclusionary rule. It extends the exclusionary rule, so it pretty much extends it to make evidence inadmissible in court if it derives from evidence that was illegally obtained. What if somebody using your information that you never gave consent for them to use? How did they get that? How did they get how much you make? How much you making at your job? How much, what your income is like? I mean, how did they get that? How did they get that Social Security number? How did they get that? Did they get it from you? Did you put that information on that application? That's something to think about. It's fruit of the poisonous tree. It's a doctrine, so if someone used information that you never gave consent for them to use in the first place, would that not be an example of fruit of the poisonous tree? Just something to think about. Just something to think about. Because I'm like, if somebody was to use, say, for instance, where's that damn form that I showed y'all in my last video? It's probably in the car in the back seat. But, got the name, the address, social security number, any previous job, information, all this information from your information that's considered it's a part of your estate. That name in all caps is the name of your estate. There's no injured party, but I'm gonna put that on an application. Keep in mind, all applications are securities. Okay, they're securities. As a matter of fact, I'm gonna go back to that Federal Reserve Act, Federal Reserve Act 16. Type that in your Google search, Federal Reserve Act 16. You can just, and let's see, number 2, applications for notes by the Federal Reserve banks. That's the name of the title. Say in the Federal Reserve, let's see, it refers to, where is it? It's a collateral security. Let's see, it refers to it as a collateral security. If you look at that, if you go back and revisit that, go read it on your own. Read it on your own time. I tell people to read this all the time. Too many videos I've told y'all to go read that. So if you're not going, I'm not going to sit here and read it for y'all on this video. Federal Reserve Act 16, that's Section 16, Part 1 and Part 2. Part 2 is specifically what I'm talking about. But, both of them go together because it explains it in detail how it goes on these applications. So it refers to an application as a collateral security. So if a collateral, so keep in mind, and it says in number 2, it says that when they turn that application in, they can return. They actually can get Federal Reserve notes in return. You know, they cash it in pretty much. They cash that application in for Federal Reserve notes for the exact amount that's written on there. Okay, so that's when they car loans or whatever. You know, court cases. I'm sure they use court cases to put with the application. If they can get an order put in place and they can put that with the application. You know, and basically, that's basically where they confirms with some kind of way they got you to consent. You first off, your information shouldn't have been on that application in the first place. That's security fraud if they didn't get your consent. That's all. It's not only security fraud, but it's also fruit of the poisonous tree because they obtained that information illegally because you didn't give it to them. That's a violation of the Constitution because it's the Constitution says you have the right to be secure in your persons, your papers, your persons. And and your property. Your all caps name is your person, right? Any information connected to that, you're supposed to be secure in that. You don't have to give the name. You don't have to give the social. You don't have to give anything if you don't want to give that. And they can't make you give it to them. That's why that's how I beat child support in the first place, y'all. You don't have to give it to them. If somebody if somebody else knows it and they give it to somebody any damn way, that's fruit of the poisonous tree because they got that information illegally. They weren't supposed to get that information. If you didn't give it to them and they use it to try to coerce you into some type of child support order, some type of agreement, and they use any type of theft by deception, any type of swindle act. You know, these words y'all need to look up. Swindle, theft by deception, identity theft, securities fraud. You know, because keep in mind the application is a security. And if they're using that information to turn you into a debt slave, which is called peonage. 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 That's debt slavery. That is illegal. Any type of slavery is illegal. So they use these types of things. As a matter of fact, oh man, damn, I wish I would have, where's that damn thing? I should have damn saved that thing. What was that? I'm going to find it. And I'm going to get back with y'all. Hold on a second. Yeah, I'm gonna show y'all something. Shout out to my partner that I talk to all the time, Seth. He showed me this. This is the Georgia Department of Human Resources, the same company as trying to represent my son's estate when they try to try me with the child support case this year. This is y'all need to write this one down, y'all. Remember when I showed y'all about Decisis? Let me make sure I show y'all that again one more time on this video. Hold up. Decisis right here. See right here? I'm probably not pronouncing it right. This is a Latin term. I think it's stare decisis. Anyway, is a doctrine that courts will adhere to precedent in making their decisions. In their decisions right here. Okay, that's a complete sentence. Stare decisis means to stand by things decided in Latin. Okay, now in case you don't know what a precedent is. Refers to a court decision that is considered as authority for deciding subsequent cases involving identical or similar facts or similar legal issues. As you see, that's what a precedent is. So this is right here. Say courts will adhere to precedent to make their decisions. Okay. If you look in, you type this word right here up, followed by your state in your Google search. For example, show you what I'm talking about. For example, let's say California. You will find you should be able to find in your in your state or whatever. Let's see, under the vertical stare decisis. Every California Superior Court must follow any published decision from any district or any division of any court of appeal. See what I'm talking about? So in just about all the states do this. I think with the exception of Kansas. I'm not sure. That's what I saw, but I'm not sure how true that is. As a matter of fact, let me see. Kansas. So the doctrine of stare decisis provides that points of law established by the court are general, I think that's a typo, are generally followed by the same court and courts of lower rank in later cases, as you see right here. That's in Kansas, in which the same legal issues are raised. Okay, the application of stare decisis ensures stability and continuity. It's showing a continuing legacy of judicial review. As you can see, you just type this same term and followed by your state and see what your state has to say about it. So obviously, somebody said that Kansas was an exception, but obviously it's not. Okay, so I had to look it up for myself to see, because the last time I followed somebody without looking this shit up, I dropped the ball. So anyway, as y'all see, now with that being said, if something was already decided in a court case, I will bring that up in your paperwork, because you can actually use this. Now, this is pertaining to child support. Okay, Georgia Department of Human Sources. Check this out. Check this out. Scrolling down. Okay, right here. About to read this right here. Back up a little bit so y'all can see that. No, I'm gonna bring it closer. The trial court declared Georgia statutory child support guidelines to be unconstitutional, concluding they violate constitutional guarantees of due process, equal protection, and privacy, and also operate as an unconstitutional taking of property. Having reviewed the matter, we conclude that the trial court erred by employing incorrect constitutional standards and an unsound constitutional analysis. Therefore, we reverse. Sound like some ammo y'all can be using to get off your damn child support case, because that's something you can apply that stare decisis, if I'm pronouncing it right, in your state. And you can use this. You can use that, even that particular what you call it, case law, to shut down a case, because they will have to adhere to previous things that's already been decided. It's been decided. It's been declared that it's unconstitutional. If y'all know about some other court cases that are, that says the same thing, you can use more. You can use all of them. You know what I'm saying? But you could use that to shut it down. And it's also fruit of the poisonous tree. So, because they also use information that they weren't supposed to use, that you didn't give, they never got your consent to use that information. That's fruit, so if they didn't have consent to use it, they're supposed to have your consent to do that. But now if you went in there and bent over and did it, that's on you if you just put yourself on child support, if they call it that. But bottom line is, I will be using the unconstitutional. I will use stare decisis and that case law. That's definitely some ammo. But I thought I'd share those two things with you guys: fruit of the poisonous tree and stare decisis. Stare decisis. I'm probably fucking that whole word up, y'all. Stare decisis or stare decisis. I could be fucking it up. It don't matter. Y'all get it. You get the point. Pronounce it however you want to pronounce it. But that, along with Rule 60. Rule 60B. Rule 60B talks about fraud, okay? So, Rule 60B as in boy. That refers to fraud. If you go and read that in your state, it tells you got to use a motion to do that. But if y'all against motions, then hell, do what you do. I'm just telling you what your state law is going to tell you to do. But do what you do, y'all. But I thought I'd share that information, and hopefully, that gives you more to fight with, more to work with. And then we'll see y'all in the next video. Signing out.